Good day and welcome to the Bills & Sundberg's webinar conducting a corporate internal investigation. Today's speakers are Bills & Sundberg's partners Marty Steinberg and Rafael Ribeiro. Litigation co-chair Marty Steinberg has particularly well-rounded experience conducting corporate internal investigations as a former U.S. Senate Chief Counsel for the Permanent Subcommittee on Investigations and former Chief of the U.S. Justice Department in New York. Marty has also successfully served as a federal court-appointed Department of Justice Monitor and as SEC receiver in significant matters, giving him an unmatched depth of expertise representing corporate clients in government and internal investigations. Litigation partner Rafael Ribeiro has conducted corporate internal investigations all over Latin America and has additionally represented individuals and companies in regulatory investigations. Rafael's fluency in Portuguese, Spanish, and French is especially useful when representing clients in corporate internal investigations abroad.
Thank you for joining us. Lawyers generally learn facts are to be assumed and legal issues are paramount. Likewise, lawyers are trained to rely on discovery solely from their adversaries. This presentation will inform you of the advantages of corporate internal investigations that are conducted correctly. Now, an internal investigation can either be proactive and may be triggered, for example, by information that an employee has misappropriated company funds or an employee or executive has received potential kickbacks from a vendor. Or an internal investigation can be defensive and reactive and typically as a result of notice from some government agency or other regulatory body that your company is being investigated.
Other potential areas for corporate internal investigations include fraud, unfair trade practices by competitors, fraudulent claims made by third parties, domestic and foreign bribery, and workplace incidents such as workplace fatalities.
Now, once your company has made the decision to initiate an investigation, the safest way in which to conduct an investigation is with outside counsel and private investigators. For example, when conducting an internal investigation, the use of internal auditors or even the company's outside accountants can be problematic because they often believe they have independent obligations to report their findings, and therefore the company may lose control of the investigation. Using outside counsel and private investigators keeps the investigation under your control and ensures that the investigation does not appear to be biased.
And why private investigators? We'll just highlight one anecdote given by a New York lawyer who led the steering committee in the World Trade Center bombing litigation. He stated, "Nowadays, it is a rare and foolhardy attorney who will do without the service of a private investigation firm in high-stakes corporate litigation. If you have the right investigator, you have more information and facts than your adversary."
Now, the most important aspect of developing evidence is the lawyer's duty to ask the next most logical question. A simple rule of thumb is always ask who, what, when, where, and how. You're sometimes surprised at the answers you receive. Lawyers have to understand that things aren't always what they seem to be. Most lawyers do not know how to or understand the significance of investigating or developing the facts, or even asking the right questions.
And before we go further on, it's very important to remember that when you do use private investigators, it is your duty to carefully supervise them. Make sure that when you're hiring investigators, you're hiring them from a company that is experienced, ethical, and familiar with applicable laws. You are liable for the wrongdoing of your investigators. That said, typically, if they are acting as your agents during a judicial proceeding, they, like you, like counsel, are protected by what is called the litigation privilege, which Florida happens to have one of the strongest in the country. That said, recent case law out of the Florida Supreme Court has held that if the investigator's conduct has no relation or connection with the subject matter of the underlying lawsuit, his acts will not be protected by the litigation privilege, and you will be liable. That is the Delmonico versus Traynor case coming out of the Florida Supreme Court in 2013.
With respect to the first contact, I usually recommend that the client send a written communication to all involved employees, notifying them of the litigation, the regulatory inquiry, or the government investigation. Otherwise, what happens if your adversary or their investigator shows up at the client's employee's door, or worse yet, the former employee's doorstep without them being warned in advance. They're likely to make or be tricked into making key admissions. The communication with the employee and or the former employee typically tells the employee that an investigator or an attorney that is adverse to the company may try to interview them. It informs the employee that they have a right to an attorney present and do not have to be interviewed without counsel, and advises them that the company will provide counsel for them. We also advise the employee or former employee to notify us of any contact. Now, why do we give this advice to employees? First, employees are generally comforted by this advice. They're going to learn through the grapevine about the litigation or the government inquiry anyway, and employees are comforted to know that their employer is on top of the issue. Second, employees will typically avail themselves of company counsel if advised that it is available. Third, there's nothing improper about alerting your employees. It's not an obstruction of justice or impermissible conflict. If a conflict later evolves where the employee has potentially damaging information, the company can then retain separate counsel for the employee. But in the first instance, the company's lawyer should represent the employee and at least interview him or her to determine if a conflict exists. Preparing the employees and having them alert you that an adverse party is trying to interview them is certainly better than finding out the hard way that your adversary or the government sent an investigator to your employee's house over the weekend or at night and interviewed him or her without your knowledge. Now, how do you help the client implement this advice? Well, I usually immediately identify personnel in the company that I will need to help gather the facts and documents for me. I send them an agent of counsel letter to ensure that any work they do protects the applicable privileges. It's also useful to have a particular point of contact at the client that's not an in-house counsel, so you can reach out to business people to get things done at a business level with the approval of in-house counsel, of course. I also typically provide the client with a document collection memo that tells the client how to preserve and collect documents, as well as preserve the chain of custody of documents. I also require clients to sign a document production compliance form that verifies the search for responsive documents. And despite it being obvious to you, I make sure the clients are aware that any communication with non-attorneys may be disclosed and discoverable. No matter who your client is, including the CEO, you must tell them that they cannot communicate by emails or in any other way about the matter unless the communications are to or from an attorney. They are discoverable. You must tell them no discussions or communications about the matter unless a lawyer is present, and no destruction of evidence, no matter how damning. The spoliation sanctions can be worse than the case itself. Finally, I send clients a memo as to precautions they need to take if litigation or a government inquiry is threatened or brought. The memo tells them the do's and don'ts of how to prepare for or comply with litigation or the government inquiry, and is aimed at protecting the applicable privileges and avoiding the creation of problematic evidence. The classic, typical emails by company officers blaming each other for the calamity after the fact are always discoverable.
As Marty mentioned, it is critical that you secure and preserve the relevant evidence, and that, as Marty noted, requires preparing the proper litigation hold. Also, as noted, it's important to resist the urge to immediately terminate or severely discipline employees suspected of wrongdoing. They are critical fact witnesses and must be interviewed and, if warranted, neutralized. Finally, investigators should be present in all interviews, and you must ensure that upjohn warning is given to the employees during those interviews.
Now, if the investigation shows that your company has committed violations or potential violations, counsel can provide guidance as to the necessity of implementing a compliance program. Demonstrating that you have implemented a compliance program may limit your company liability. A compliance program should meet the criteria set forth in the United States Sentencing Commission's federal sentencing guidelines for organizations, even though there's disagreement as to whether the guidelines still apply. There's 7 basic ingredients of such a program. First, the organization must have established compliance standards and procedures to be followed by its employees and other agents. Second, a specific individual with high-level personnel of the organization must have been assigned overall responsibility to oversee compliance with such standards and procedures. Third, the company must have used due care not to delegate substantial authority to individuals who the organization knew or should have known through the exercise of due diligence had engaged in illegal activities or other conduct inconsistent with an effective compliance program. Fourth, the company must have taken steps to communicate effectively its standards and procedures to all employees and agents by requiring participation in training programs and by disseminating publications that explain in a practical manner what's required. Fifth, the company must have taken reasonable steps to achieve compliance with its standards by using monitoring and auditing systems reasonably designed to detect criminal conduct by its employees and other agents, and by having in place and publicizing a reporting system where employees and other agents can report violations by others within the organization or seek guidance without fear of retribution. Sixth, the standards must have been consistently enforced through appropriate incentives and disciplinary mechanisms, including, as appropriate, discipline of individuals responsible for the failure to detect an offense. And finally, after an offense has been detected, the organization must have taken all reasonable steps to respond appropriately to the offense and prevent further similar offenses, including any necessary modifications to its compliance and ethics program. Now, it's important to note that compliance programs are valuable to your company's bottom line. Companies should develop an economic rationale for risk management to demonstrate the cost savings as a result of compliance programs and risk management. The typical refrain we hear after a disaster has occurred is that the company did not want to spend too much money on lawyers, compliance programs, or risk management because they were not profit centers and were just a cost item. When the risk management or compliance program saves your company the humiliation of discharging your CEO for embezzlement or the financial pinch of a class action judgment in the tens or hundreds of millions, that should easily justify the cost. These cost savings go right to the bottom line.
Let's now address the issue in a little bit more detail about preserving the privilege relating to corporate internal investigation materials. An entire webinar could be done on this subject alone, but we're just going to highlight a few important considerations. Taking a step back, let's just briefly review the basic elements of privilege under U.S. law. 1, a communication must be at issue. 2, the communication, one of the significant purposes of communication must have been to seek legal advice. It can't, for example, be only about business advice or any other non-legal advice. The communication must be between a lawyer or its agent and the client, and the communication must be made in confidence, or else the privilege may be waived. As we noted earlier, your internal investigators are your agents, so their communications with clients are privileged. As Marty noted earlier, as a general practice, we engage investigators and other vendors and professionals through the agent of counsel letter. In the agent of counsel letter, we expressly instruct the investigator or agent that they are being retained by external counsel, not the client. We like this to create the layer of separation between the client, the investigator, and the vendor. Any materials prepared by the investigator are to be treated confidentially and constitute attorney work product. The investigator must keep the materials confidential even after the termination or expiration of his tenure. For administrative purposes, we ask that our investigators submit the invoices to counsel, again, to create the barrier between the investigator and the client. We also like to have similar agent of counsel arrangements when hiring, testifying, or consulting experts. Briefly, there are 2 bodies of law that govern attorney-client privilege. At the federal level, it's the subject matter test as set forth by the United States Supreme Court in Upjohn. In Florida, the test is similar to the subject matter test articulated in Upjohn, but it is actually codified in Statute 90.502 of the Florida statutes, and also set forth by the Florida Supreme Court in Southern Bell Telephone and Telegraph. Now, It may seem obvious, again, but it is important that you ensure that all your communications relating to the internal investigation be identified with the heading attorney-client privilege or attorney work product. It's a simple measure, but it's an effective one. As Marty noted, document only what you need to in the interim prior to the final findings of any investigation. And be careful with respect to disclosure of internal investigation materials. That may constitute a waiver. And this is no academic matter. As recent as June of 2014, the issue of disclosure of internal investigation materials came to the forefront in a now infamous case known as the Barco case. In that case, a federal district court ordered KBR to turn over notes stemming from an internal investigation relating to fraud during the performance of government contracts. Interestingly, the district court found that because KBR had engaged in an investigation pursuant to its code of business conduct, the district court found that because it wasn't initiated by external counsel or even supervised by internal counsel, that those notes were not privileged. Indeed, the district court found that the purpose of the investigation was not to obtain legal advice, but it had only been done pursuant to the corporate compliance program. In summarizing its position, the district court found that because the corporate compliance investigation was not for the primary purpose of seeking legal advice, KBR is not entitled to the protection of the attorney-client privilege. On appeal, the Court of Appeals for the D.C. Circuit reversed. Discussing Upjohn, the D.C. Circuit held that the proper test to apply is whether seeking legal advice was one of the significant purposes of the communication. Applying that test, the Court of Appeals found that the KBR internal investigation materials were protected and should not have been disclosed. That said, although KBR ultimately prevailed at the appellate level, it certainly experienced a moment of panic when the district court ordered the disclosure, and there are lessons to be learned. Ensure that counsel, either internal or external counsel, is supervising the investigations, and ensure that the materials are being prepared at their request. Make sure that at least one of the significant purposes of the internal investigation is to seek or provide legal advice. And as noted earlier, retain all of your investigators or other professionals as agents of counsel. And now we're going to touch on the area of corporate internal investigations that cross borders. And there are some particular considerations to keep in mind if your internal investigation includes actions that will take place outside of the United States. And the first consideration is to engage competent legal counsel locally. Why? It is impossible for U.S. counsel or internal counsel to know the nuances of local law with respect to internal investigations. There may be privacy, bank secrecy, and data protection laws in those jurisdictions that you need to be alerted to. Also, overseas, the local jurisdictions may have some aversion to U.S.-style internal investigations and may see those as invasions of privacy of their employees. As commented by internal counsel of a large corporation at a recent ABA event, one of the biggest mistakes that an investigator can bring to a foreign investigation is an American mindset. The other issue to think about when your internal investigation crosses borders is whether those communications will be privileged. In some jurisdictions, there is no such thing as an attorney-client privilege. And in other jurisdictions, there are distinctions to be made about whether the internal counsel has that privilege or not. And again, we have some significant case law coming out of the Second Circuit on this issue. The case recently came out, and it is called Villeron Holding. Came out of the Southern District of New York, and the opinion was issued on August 22nd, 2014. In that case, internal counsel in Russia and the Netherlands were discussing a matter with their executives. There was no connection with the United States at that point. the court went on to examine that in Russia, unless the lawyer is registered with the Russian authority that regulates attorneys, then that internal counsel does not have the attorney-client privilege. It also went on to find that in the Netherlands it was a similar situation. After analyzing the attorney-client privilege in those jurisdictions, the court went on to find that those materials were not privileged and needed to be disclosed. Although Veleron wasn't an internal investigation case, it's important to remember that when you're communicating with internal counsel or even external counsel abroad, always be careful about how that jurisdiction treats the attorney-client privilege. Location and documents of data abroad are another consideration. Are you authorized to bring that data to the United States to review? In some jurisdictions, data protection and privacy laws may prevent you from doing so. Experts recommend that you build a cross-border data export channel to facilitate exporting of data if you need to review it for an internal investigation. A safer bet, which we have done before, is to actually deploy external counsel to that jurisdiction, set up a war room there, and review the materials while you're there. And again, use of investigators and outside counsel can be fine in a cross-border investigation. Just make sure that in that particular jurisdiction, investigations can be conducted by private investigators. Some jurisdictions prohibit that. Some professional bar associations in other jurisdictions also may prohibit lawyers or their agents from conducting investigations. And this is no academic matter either, because as shown by a recent event in France, it was an IKEA internal investigation. There are potentially public relations and legal ramifications to internal investigations. In the IKEA investigation in France, which was featured in the New York Times article, the IKEA executives in France suspected that one of their directors, who was out for sick leave for over 1 year, was not actually sick, as she was claiming. They instituted an internal investigation and ultimately terminated the employee. Well, she filed a lawsuit, and the details of the investigation were leaked. It turns out that IKEA may have violated French privacy laws in conducting the investigation. Several of its directors and officers were subsequently fired. So again, it highlights the importance of getting someone on the ground that knows the local jurisdiction to make sure that what you're doing is permissible.
All right, it's Marty Steinberg. As Raphael said, there are many nuances to foreign internal investigations. Since we practice in Miami, Florida, we're involved in foreign internal investigations quite frequently. Some issues that you might face are the following. In Europe and other jurisdictions that have robust data protection laws, they might deem an employer's in-house internal investigation protocol what they call, quote, a system for processing personal data, and therefore subject to that country's data laws. They can make this determination even before a specific investigation launches that would implicate actual personal data about individual employees. Many European jurisdictions, for instance, affirmatively require that employers disclose both to the local data protection authority and to the actual employees themselves, which they call the data subjects, their investigatory processes. In addition, labor laws in Europe and elsewhere can require disclosing the in-house investigatory framework to employees' representatives, like work councils and health and safety committees. Labor laws may also require bargaining or consulting over these investigative processes with employee representatives. Now, to Americans, all this disclosure and consultation over an internal investigation seems highly intrusive. American multinationals like to keep their investigative tactics confidential for the same reasons the FBI doesn't broadcast its investigative techniques. But a multinational corporation may have to bite the bullet and disclose the outline of its investigative processes to simply comply with local data protection and labor laws. It's counterintuitive, but this may later free up the company to conduct broader international internal investigations when the need arises. Also, to guard against data privacy and defamation claims and to avoid human resources and public relations problems, you must limit the investigative information to those with an actual need to know, typically the investigation team, retained experts, auditors, counsel, upper management, and maybe the board of directors. Resist the temptation to keep too wide a circle informed as the investigation proceeds. Also, transmit investigative data back to U.S. headquarters only pursuant to the local legal restrictions on data privacy. Unless a self-identified whistleblower expressly consents otherwise, overseas data protection laws may, in theory, mandate preserving the whistleblower confidentiality. But in practice, maintaining whistleblower and witness confidentiality can be tough, where circumstances point to a source and where the whistleblower is or becomes the complaining witness. This is virtually inevitable with a harassment complaint, for instance. A best practice is to never guarantee whistleblowers or witnesses absolute confidentiality. Now, you should also not impose immediate discipline on employees unless it's necessary under that country's laws. Typically, we recommend taking interim steps. Even where a target's guilt may seem clear at the outset, employers conducting internal investigations should not impose discipline in it until after they complete their investigation. After all, the very purpose of an internal investigation is to find out whether discipline is appropriate. To impose discipline at the outset of an investigation flies in the face of what an investigation is supposed to be. Indeed, to fire even a seriously implicated employee at the launch of an investigation would seemingly defeat the purpose of that internal investigation. The logic seems sound, but it betrays an American mindset. In overseas investigations, immediately check whether local laws impose an almost instant discipline deadline. Some jurisdictions impose tight deadlines of only hours or days, during which the employer can legally invoke evidence or misbehavior as a good cause support for firing. In some jurisdictions, the firing of an employee for cause must be reported to the local labor office, for instance, in 24 hours of the time of the incident, not 24 hours after the internal investigation winds up. In some jurisdictions, an employee's dismissal for good cause must not only occur within so many days from the moment the facts are known to the employer, but then require the employer to notify the dismissed employee by registered mail within so many days of the date of the dismissal. In these jurisdictions, the clock might start running as soon as the employer gets solid, credible evidence, and not after it formally wraps up a full-blown investigation. Even where the law does not require imposing fast discipline at the outset of an internal investigation, you should take any necessary interim personnel steps, like imposing a suspension, paid or unpaid, or separating an accused harasser from an alleged victim. And oftentimes, before you sanction or dismiss an employee, they're still theoretically loyal to the company and may provide you with valuable information. Now, after securing documents, the time comes to interview witnesses. In conducting these interviews overseas, there are many overseas legal, cultural, and strategic issues. During these interviews, you must comply with the local workplace laws, employment data protection laws, and so forth. Now, an American lawyer or investigator preparing a memo announcing an internal investigation might announce that all the employees must cooperate with the internal investigation. And American investigators like to begin employee interviews by insisting that each witness cooperate fully. We can get away with this in the United States because this approach works well under U.S. employment at-will laws. But this can backfire abroad. Almost universally outside the United States, foreign laws let employees refuse to cooperate with their employer in an investigation. Most overseas employees get a labor law right to remain silent, roughly analogous to the American Fifth Amendment in the police investigation context. Americans may think they have good cause to fire an employee for refusing to cooperate in an internal company investigation overseas, but little, if any, authority abroad supports this view. Indeed, whistleblowing rules in Europe actually forbid employers from unilaterally imposing mandatory reporting rules such as codes of conduct, to force witnesses to disclose incriminatory information about their coworkers. An employer order, as opposed to a request to cooperate with an internal investigation overseas, likely triggers the same legal concerns that may be an impermissible mandatory reporting rule. Lastly, consider the pros and cons of delivering an oral versus a written report to upper management detailing the investigation's findings. Keep in mind data subject rights of access to a final report and restrictions on exporting investigative data overseas. Data protection laws and privilege rules may weigh against a written report overseas. If you must draft a report, draft any report carefully with findings of fact grounded in evidence. Refrain from declaring anyone guilty of a crime or characterizing events, and limit the circle of upper management receiving an investigatory report to those with a demonstrable need to know. Where an investigation uncovers solid evidence of wrongdoing and where the employer did not already take action at the beginning of the investigation, it's important to impose discipline consistent with the investigative findings and upper management buy-in. If the investigation exposed enough evidence to dismiss the subject for good cause under local law, structure the dismissal as for good cause. But sometimes an investigation uncovers enough evidence of wrongdoing to convince an employer to dismiss the target, but not enough evidence to support a good cause dismissal under tough local employment laws. In those situations, the employer, where it's legal, might decide to dismiss the target not for good cause and paying severance pay. In dismissing a guilty target, whether or not for good cause, follow the local law's dismissal procedures. Many countries impose detailed dismissal procedures on employers firing even obviously culpable staff. It is also critical when disciplining a witness, a whistleblower, or target who had lodged a workplace complaint to strictly comply with the anti-retaliation laws, such as the laws in Europe that prohibit victimizing whistleblowers.
This is Raphael now to pick up on the point that Marty discussed a little bit earlier, which was the particular nuances regarding the attempts to export employee data out of certain jurisdictions, such as the European Union. These countries also have enacted what are so-called blocking statutes that prevent the exporting of certain types of data, documents, or information out of those jurisdictions. In the context of an internal investigation, blocking statutes may come into play if you're transporting data out of these jurisdictions for review and that later this data be subject of a subpoena in a U.S. civil or criminal matter. Once the data is subpoenaed, courts in the U.S. may compel compliance with discovery even if a blocking statute in the source country would impose sanctions. For example, generally speaking, France's blocking statute prohibits any person to request, research, or communicate in writing, orally, or by any other means documents and information relating to economic, commercial, industrial, financial, or technical matters leading to the establishment of evidence in foreign, judicial, or administrative proceedings or as part of such proceedings. The terms and definitions of this blocking statute must be considered carefully in the context of an internal investigation, as they may be more broadly applied than anticipated. For example, if you collect this data as part of an internal investigation in cooperation with the U.S. government, or the data otherwise is shared on an ongoing basis with the U.S. government, the French blocking statute may apply and you may run afoul with that jurisdiction's laws. Also, as Marty mentioned a little bit earlier, certain foreign jurisdictions may require that you actually alert the target of your investigation of the ongoing investigation or actually disclose the results of the internal investigation with the target. For example, in the European Union, one of its governing bodies has decreed that an employer must inform the target employee as soon as, quote, there is no substantial risk that the employee, end quote, will jeopardize investigation. Clearly, this would have an impact on the way in which you handle your investigation if it is being conducted in the European Union. Make sure that your local counsel gives you guidance on this issue, and remember that an investigation that does not comply with local laws may not only be ineffective, it could lead to enforcement actions against your company in that jurisdiction. Finally, as discussed by Marty, not only may employees have the right to refuse to cooperate, they also may have the right to have a third party present during an interview, such as a union or labor association representative. Also, some foreign jurisdictions require that the employer give the employee the right to have an attorney present during the interview. As Marty mentioned, foreign privacy laws also may provide protections to employees that could excuse them from submitting to questioning by counsel during an internal investigation. You definitely don't want to compromise the efficacy of your internal investigation by finding out later that the results are unusable because of the failure to comply with representation rules.
So I'm now going to talk about a couple of case studies, not the typical SEC internal investigation, but internal investigations to protect the company to illustrate how investigations are optimized. And the first one of our clients, a large manufacturer and distributor of beverages, sent us a complaint that had been filed against them in Connecticut regarding a contract that had been signed by one of the client's executives for the purchase of 5 million promotional drink glasses from a Greek glass manufacturer. The contract had the signatures of the client's procurement agent, had the signature of the chief executive in charge of contracts, and had the signature of the Greek glass company vendor. The claim filed against our client was for a breach of contract for ordering 5 million promotional glasses but failing to pay for them. However, the client's employees who were involved in the transaction had already left the company, and no one internally knew what was going on. The client, a large company, felt this was a minor matter, wanted to settle it quickly, even though the settlement was in the millions of dollars, and this was one of the scores of approved vendors for glass products it used. The client instructed us to prepare the settlement documents and releases that were appropriate for this situation. The most important aspect of developing evidence is the lawyer's initial duty to ask the next most logical question. So we did. Could the company verify that it actually received the decorative glasses? Sure enough, a few days later, embarrassingly, the company got back to us and told us that no one could verify the receipt of the glasses. That's when we hired investigators to take a look at this transaction. Within days, the investigators discovered the following. The Greek company who sued our client and demanded a settlement had never even manufactured the glasses. We located the former executive for our client that purportedly had signed the contract in the middle of nowhere in Indiana, where he had retired. He looked at the affidavit, he looked at the contract, and signed an affidavit saying his signature was a forgery. We then located the Greek glass manufacturer's former employee who purportedly signed this contract with our client, and he lawyered up and took the Fifth Amendment. We then discovered emails that supported our suspicion that the claims had been fabricated. We presented this evidence to the Greek vendor's U.S. counsel and said, look, you may not have known this when you took the case, but your client's a fraud, and we're going to go to court and ask for sanctions against you unless you withdraw your complaint. In a few days, the case was dismissed, and the client didn't pay 1 cent. Going back to what we discussed earlier in the Greek glass case, the next most logical question to the client was, did you actually receive the merchandise you're about to pay more than $5 million for? The client didn't ask that question because it had an invoice, a purchase order, a qualified vendor, an email chain of approval from the officers. There was only one thing missing, the product. Here, our investigators did a great job of uncovering the fraud, but the lawyer initiated these events by asking the next most logical and common sense question and not assuming everything despite what he was told by his client. The second case study deals with another international beverage manufacturer suffering unexplained losses. There were warehouse shrinkages, that is, the unexplained loss of inventory, at a national citrus processing corporation that was costing millions of dollars. They asked us to determine the source of these massive losses. We retained investigators and discussed a variety of investigative techniques to gather evidence. We finally decided to have the investigators install hidden cameras in the warehouse and ghost keys on the various employers' computers. Ghost keys create a mirror image of what's being typed on the employee's computer on a remote computer. By comparing the ghost keys to the timed videotapes, the investigators determined that a trusted supervisor had been systematically altering the company's secure inventory database to conceal his diversion of inventory. The employee had established an off-the-book relationship with distributors of the company and sold them excess products which he pocketed. He made millions of dollars in this way. He then entered the company's purportedly secure inventory control database and deleted the exact amount of products he sold on the side so that the inventory database matched the physical inventory count. The investigators' creative video and computer surveillance resulted in evidence being gathered against the supervisor, his cohorts, and the distributors, and at their client's request, the investigators interfaced with law enforcement, resulting in the arrest and prosecution of these creative thieves. The third case study involves an international transportation company. A former vice president of operations, a high-level position which afforded him unlimited access to confidential and proprietary information and business secrets of our client. When he was elevated to this status, he, like all the other senior officers, also signed a confidentiality agreement. He also entered into an agreement containing a provision that he would not solicit employees of the client or customers of the client. All the while that this was going on, this executive was secretly removing the client's confidential and proprietary data to set up his own business. The executive also established close relationships with executives of his employer's customers. He then resigned from our client and opened up his own business. Shortly thereafter, the client received a call from its most significant customer in that region, advising that for the first time in 15 years, they were going to open up bidding for other bidders in California, which was the location of our client's former officer. The former officer's new business submitted a slightly lower bid and took the account away from our client along with two key managers from our client. Using a computer forensic expert, the investigators obtained the former officer's laptop that he had left at the client. Of course, he deleted all the material on that laptop, but they recovered the vast majority of the data that he thought he had deleted from the hard drive, including the actual business plan used by his employer, his prior employer, with the name of his new company inserted as if it was his plan. They also obtained from the computer data emails, expense accounts, contacts, evidence of solicitation of our client's customers while the officer was working for the client. It was also determined from emails that they recovered from his computer, which he had deleted, or thought he deleted, that he had a former mistress, now estranged and highly disgruntled, who became a very interested witness against the former officer. She was interviewed by the investigators and told them about his activities of soliciting our client's customers while he still worked for our client. At the deposition of the defendant, he was confronted with all of the information the attorney's investigators had obtained, none of which was obtained in discovery. So he and his attorney were completely unaware of what he was about to be confronted with. When he was faced with these facts, he made critical admissions. As a result, we obtained an injunction against the officer and his company and essentially put him out of business. Thank you.
Today we highlighted some of the best practices and also discussed case studies on conducting a corporate internal investigation. We thank you for your time, and we welcome any questions you may have.
We understand there's one question asking who should lead such an investigation. We believe the safest person to lead an investigation is external counsel to protect all the applicable privileges and work product. Thank you very much for your attendance.
This does conclude today's conference. Thank you for your participation.